Good afternoon. This is Alejandra Reyes, and today's video it's for week 4 discussion. For this week, we were asked to present 5 different points. The first point is point A, and this is in regards to the Family and Medical Leave Act. The Family and Medical Leave Act, also known as FMLA, it's a federal law that protects employees from taking time off during catastrophic events, medical emergencies, etc. Most of the people that take advantage of this benefit are pregnant women, and they usually use this time, which is up to 12 weeks, when they are having their babies. So when they have to go home and after the hospital, they can take up to 12 weeks and they are protected. Their jobs are to be held for them for at least 12 a 12-week period. Other family members can also take advantage of this benefit, and it could be used when they are sick, children, and immediate family. And they can be protected as well from not getting dismissed from their jobs. The FMLA unfortunately does not cover pay for the employees. They can take unpaid time. Some of the employees that might have accumulated vacation, sick time, or PTO hours, whichever the employee calls it, they're able to use all of their PTO or vacation until it's exhausted. Section B is to conduct a research online of a legal case regarding the FMLA. A release dated January 2013, annotates that a judge ordered an Arizona worker to be offered reinstatement of his employment, back pay under the FMLA Act. This case happened in the Phoenix area. An Atlantic, Georgia water company based out of Atlanta recently acquired a company in Mesa, Arizona, named O Premium Waters. The driver was working at the company and had a family emergency. His wife had a recent accident, and she had neck surgery. The driver, the husband, needed to stay at home with his wife and care for her. And he was able to take the FMLA leave. The employer had authorized for him to leave, and this is the old employer or Premium Waters. When he left, he believed everything was in check. After a couple of months, he did not return to work. Exactly 5 months had passed by, and the driver did not return to work. He found out that the company that recently acquired the company that he was working for had fired him on the spot because he did not return to work after the 12-week period. He found himself without a job, with no pay, and he wasn't able to return to work to make his end meets, his living. He also found out that he was left with no medical coverage, and due to his wife's illness, it was really important for him to have that. The Department of Labor Hourly Wage Commission found out that this driver was fired in a way of discrimination. The Department of Investigation also found out that Sparkles had owned or had purchased most of the employees, but leaving out this one driver that was on medical leave. Because of this reason, Sparkles refused to rehire the driver, but it was determined that it was unlawful. To resolve all the violations, the driver was reinstated to his job. He received back pay and also medical benefits, full medical benefits. This was one of the cases where the outcome was positive, although there's a lot of cases out there that do not get resolved successfully, and discrimination, and for many other reasons, they don't get resolved. And there are a lot of employees that end up with no jobs, no medical help, and in bad situations, unfortunately. Section C is related to internet search. Um, can somebody be fired for posting something online for a social media and any platform available nowadays? The answer is yes. Um, it's not a law per se, but employers do look at your social media posts. They look at prior to you becoming an employee of the organization and then also during your employment. The reason why this is because if, for example, you're working for a church, your social media posts are not according to what their beliefs are, the mission of the church or the agency that you're working for. If they are contradictory to what the company is trying to portray to the public, it might be something that could be considered terms for termination, grounds for termination. I'm sorry. Also, a lot of the times, people post things as jokes that could be discriminatory, and they can offend public and they can offend other employees, stakeholders, etc. Some of these posts that are inappropriate could also be grounds for a hostile environment for the rest of the employees, and employees cannot take that risk. Remembering that all employers have to follow certain rules and regulations from the government, the civil rights, for example. So, some of these comments that somebody might just post as a joke or trying to be funny, it wouldn't go, and it could cause harm to the organization or the employer. And while you are going through an interview, some of the posts that prospect employers find in your social media might be red flags as well. Maybe showing the prospect employers a side that maybe you're not showing in an interview or in your resume, so that could lower the possibilities of you getting employment there. Also, some of these posts that could mean, or they could be posted as jokes, could be of illegal practices. And again, the red flags for prospect employees and for current employees as well. And finally, the answer is just yes. Yes, you could lose your job for inappropriate social media posting. Section D. In regards to an employee losing their job over a social media post. The following case, it's an employee being terminated for a Facebook post regarding a racist comment that she made on her social media. In May of 2022, New Jersey, McVeigh versus Atlantic Care Medical System. A nurse, an employee of Atlantic Care Medical System, posted regarding the Black Lives Matter movement. She posted Black Lives Matter. It's a racist a phrase of segregation, she wrote. And she also wrote that Black people are killing themselves. Later on, she went into her media post and she tried to explain herself, saying that all lives matter because she's a nurse and that she was in this field for that same reason. She was fired because of this post, but she was fired for other reasons, for her having poor management, judgment. So the nurse um, was discharged, and she thought she was discharged on wrongfully. So she sued Atlantic Care Medical Center back. There were some instances in the Atlantic Medical that there was a policy about social media and stating that the employees are not, or I'm sorry, the employer is not responsible for employees' posts. Um, so when this nurse tried to sue the company, she wasn't able to get anywhere with that case because there were two different reasons. There was a reason why she got fired, according to her employee, and then there was a reason that, according to the employer, it wasn't related to social media posting. So she was denied the court case. The court advised that all employers should review their social media policies, but at the end of this case, the nurse wasn't able to get her job back or anything like that. It was concluded there was no wrongful termination, and that it wasn't related to her social media post. Section E, it's in regards to sexual harassment at the workplace, and I believe outside the workplace as well, in any case scenario. The question in this section is if harassment needs to be in a sexual nature, and it is not. Although harassment does not prohibit simple teasing, fool play, like they say, if it becomes a hostile environment, it is considered harassment and it is illegal. Teasing in the workplace and any other type of environment could be seen as foreplay, a joke, etc. But if it is unwelcome by the other person, it is considered sexual harassment. And it becomes very uncomfortable for the person being the victim. Um, the oppressor can be a supervisor, can be a co-worker, can be a customer, can be a neighbor, can be a friend. So as the offender, you should think if the person is giving you negative feedback, you need to stop because it could be sexual harassment. You can get into a lot of trouble for that legally. Um, and if you are the victim, please do not hesitate to look for help. There is a lot of help, and I know this is not in the 5 paragraphs that we were assigned, but there is a lot of help for victims out there. There's a lot of there's a helpline. The number to dial the helpline is 1-800-656 HOPE or 4673. They're open 24/7. If you're a child, if you're a young adult, if you're a grown person, if you're an elderly person, you could all be sexually harassed. The matter is, you need to identify if you're in this situation and need to get help. Nobody should be going through this type of things. Although a lot of the times we go into these hostile environments, like I said, with family members, friends, etc. A lot of times, coworkers or bosses, because they think they have the right to do something like that to a person, but there is help. So please seek out help, and you could be a victim, but it gets easier. It gets easier, and you can get help, and you can have a healthy mind again. Thank you for your time.